to come straight away to the security guard, that is at page 34.
Yes, page.
And what the trial court says is that he didn't make a spot panchnama. And that's the only, just one thing, just keep in mind that the security guard on the same day gave a written statement detailing everything, number one.
Did he abide
Number
by
two, his workman gave a confession statement signed.
See, did he renege the security guard from a statement?
Never.
Let's see.
Yes, page 34. Kindly come to the second paragraph 34 on 2nd June.
Yes.
On 2nd June 2012, I was working in the third shift. On that day, I was working at the main gate. After the completion of the time of the shift, the bus number so-and-so was stopped on the gate. At the time of checking the bus, the delinquent chief was sleeping. On the bag was, one bag was under his seat. Hence, I awakened Mr. Pawar and asked him, whose bag is this?
Okay, sure.
Shinish Kumar told me it is his bag. He said this in his written. Yes. Cross-examination was on the page 37. On 2nd June, first there's one para in the previous para about his previous working, etc. Not very material. 37. On 2nd June, I was in third shift. In second shift, Tanaji Dhane was on gate in second shift. It is true that it is not mentioned how many persons were in the bus. It is not mentioned in my report. Panchnama has not been drawn where the bag was found. It is true that description of the bag is not mentioned in the report and statement. He says it's his bag.
All right.
He gives it in writing.
Notice a statement.
And statement.
Your judgment shall remain stated for the
Item 15.
Thank you.
Let's stay on proceeding because otherwise we'll have to de novo evidence.
You have said operation of it. Judgment shall remain stated. Yes. Yes, please.
All I'm asking for is an opportunity to argue and cross-examine the complainant. Now, there are 3 ex parte orders passed against me. First,
why should we extend that privilege to you with your conduct?
Yes, ma'am.
Thrice you lost the right.
My conduct.
Who have been dragging your feet at every stage. You don't deserve any indulgence as a husband.
Because we come to page 45 is annexure P14.
Make your point.
Because we filed a mutual consent divorce petition.
Then what happened? Then you didn't appear. Then you chose not to appear.
No, I did not choose to. She appeared on 31st of May 2023.
Yes.
The next day,
it was dismissed as withdrawn.
No, please say.
It was dismissed as withdrawn on the 31st of May.
Page 51. The next day is 16th November.
Come to page 16.
P16 is where she appears out of turn and withdraws it without notice
What
to
did
me.
she make a statement that she wishes to withdraw? If she wishes to withdraw, that option is available to a party till the second motion.
Yes, because I understand, but I was not given any notice whatsoever.
You did not get a notice, assuming for a moment. You were not given notice, assuming. And there was an error. Fact of the matter is, in a matrimonial relationship, one of the parties says, I gave a statement in the first motion, but I don't want to go further in the second motion. That gap and the hiatus between first and second motion is for party options and take a call. If she did, whether you were there or not, it wouldn't matter. One of them is not interested.
I'm not challenging that one. Because what I'm saying is at page 51, when the first motion was done.
So you are registering the divorce?
16th
No, are you registering the divorce?
Absolutely not. We are resisting the divorce.
Why are you resisting the divorce having gone that way initially?
Ex parte order passed.
Either on mutual consent.
Ex parte order passed. Your divorce petition dismissed default. Same day you file application restored. Again ex parte.
That's how you.
That was allowed.
You conduct us.
51.
So
51.
we don't
Next
see
date is 16th November.
Yes.
Then she withdraws it on 31st May.
Why?
And when she withdraws it on 31st May, on the very same day, the consent.
No, she withdraws the consent. She withdraws the consent for mutual divorce.
Yes.
Can always withdraw it. There's nothing to stop.
I understand.
You don't need to be there for
So
a.
she wanted to fight and take a decision on merits, not mutual. Only the mutual part was withdrawn.
Maybe I'm not conveying it properly because what I'm saying is I am not on the fact that she cannot withdraw. She can withdraw, no doubt about it. All I'm saying is on 31st May when the mutual consent was withdrawn by her, on the very same day the contested divorce was also listed.
Sorry.
And in the mutual consent, one of the terms withdrawing
Spira's family court, you were proceeded ex parte not once, not twice, but thrice.
Yes.
19/8/21, 8/9/22, 31/5/23. This is how you were conducting.
Two orders have been sent.
What are you doing?
May I just say, even so far as the second order is concerned, let me just have page 24 for a moment. On the very same day, the
Anyway, no purpose is going to be served. No purpose, no purpose.
Please restore it.
No purpose is,
Then I'm proceeding.
no purpose will be served. It will be more acrimonious. The only thing it will be only acrimonious. Otherwise, nothing.
An opportunity because of your point.
31st May, why am I
No,
proceeding?
we are
Starting
sorry.
was
We are
that
sorry.
sorry.
But you chose to go that way. Next. Yes, thank you.
Item 16, I'm seeking a password.
Like, transfer application was rejected. The wife has.
110 kilometers, you can also cover.
Wife, husband is attending the 498 proceeding at Penda Road. He can come.
All right, notes.
Item 18, net is election. The respondent number 3, my lord, was transferred from X to Y on 18th of January 24, and 18 days later, my lord, he was transferred again. The respondent. To my lord, my place. To my place, and I was transferred, my lord, to the place that he was.
For how long did you occupy that position?
Because I had occupied, sorry, my lord.
Then your appointment.
I had occupied my position for 2 years.
So that was the period normally, but for
It is the minimum period. It is the minimum period.
any time after 2 years, you could have been transferred.
That's correct, Milord. But here is a case, Milord, where, as far as respondent number 3 is concerned, we have been able to show that there were, Milord, only recommendations from, Milord, MP, MLA, and, Milord, based on those, Milord, recommendations, Milord, in 12 days, Milord, he is transferred again. Now, Milord, just see the order. Milord, the impugned order, Milord, when we went up on appeal,
Yes.
against the interim order, Milord, the court said, I'm adjourning this matter till after the hearing of the main matter is over.
What happened with the main matter? That was 19.
No, it's not yet. It's Milord, pending now.
What is the next date?
The next date is 19th March or something. 18th March, Milord. Milord, just see one line, Milord, on page 3.
Yes, we've seen it. That's why we are.
This is this.
So, anybody appearing on the other side?
I'd like to prefer respondent.
What is your stand?
Now, as far as I have taken charge, why the?
You are the private respondent.
Yes.
For the
Yes.
state.
We have not.
No, Mr. Anand, only answer one query.
Yes, Milord.
Was your case for transfer recommended by the MP and MLA or not?
It
Yes
was.
or no? Then you are required to be proceeded against what to call of transfer.
Milord.
On that very ground only we will interfere.
Because I understand, Milord. However, Milord,
We will not tolerate this interference.
prior to that, Milord, the Lordship sees, prior to that.
Whatever is prior to that, we are not concerned.
No, I was
The moment they come,
Why did you
what?
ask?
Why did you ask on that ground itself? And will observe that you may be proceeded against for this misconduct.
Milord, sir, kindly see.
No, this has to end. This has to end somewhere.
Advantage of your connections and
And
time good springs.
We are lucky to have such a case before us so that we are able to interfere and do something.
Milord, before the recommendation was made, Milord, in fact, I was already, Milord, proposed to be transferred to that very place.
Why did better?
Why did you get recommendation? You
Why?
wanted to flout your connections.
Milord, I understand.
So you go back.
No, Milord, I
You suffer the
understand.
consequences.
Yes, Milord. Now, if the Lordship sees,
Recommendation.
22 onwards, Milord.
22.
22.
Okay, 20.
22 is the MP. And see the letter.
Yes, that's.
So and so now posted in Namsai, has excellent track record of performance as an administrative head, and now he is willing to be posted in Pasighat. He has taken charge, Milord, on that date.
So he is willing. He is as if
He is willing.
the system is obliging him that he is willing to go there.
The next page, 23, is an emitted. Same thing, he is willing.
Right.
Identical letters, 3 identical letters, Milord.
Note to current counsel for the respondent number 2, booking counsel's name.
3.
Who's on caveat. Caveat
Yes, sir.
accepts notice. Not
On
a.
instruction.
Not its.
May not be on caveat, but
Accepts notice counter affidavit be filed within 2 weeks, rejoined in 2 weeks. In the meantime, it is directed that now, who's in position today?
Milord, we are, I have taken
No, no, but I have
Shall continue to function from the post
From
of,
which he was transferred.
post of
we
which.
have already taken charge. Milord is where I am.
Stop paying back.
Yes,
They restore a status and
From which I am being transferred.
Even if it is there, then it will be restored and set up empty.
Please tell us what's going on.
Pasiga.
So what post are you on?
Oh, I'm sorry.
SCRWD.
Superintending engineer.
Superintendent.
Yes.
The petitioner shall continue till further orders. Petitioner shall continue to discharge his duties as a superintending engineer at
No.
RWD.
C or the RWD.
RWD, Rural Works Department probably.
Yes.
Pasighat.
It's corrected if you are wrong. You
Yes.
don't want to make an error on the assignment.
The petitioner is now in Pasigat. The respondent number 3 is in Itanagar. They are supposed to be
We are not asking you.
Yes.
From the place where you were working earlier, what is your position there?
Superintending engineer.
Where?
Below RWC.
RWD. Not
RWC.
It's RWD. Correct yourself, Mr.
Below page 21, my lord, I find Sri Renia Tamin, that's the petitioner. Superintending engineer, RWC Pasighat, Rural Works Department, Pasighat.
As superintendent
Page 21.
engineer, RWC Pasighat, Rural Works Department, shall continue to discharge his duty as so and so.
Milords, may I say one thing?
High and dry for some time.
No, Milords, I understand, but as factually, Milords, factually, I have already taken charge.
It'll amount.
It is quite not on that.
No. It'll amount to that. We say that he will be there. What the government does, let them do. You have a very strong connection. Accommodate you somewhere. They are not bothered about
The
it.
case, no?
Nobody of
They are not bothered about you.
say that you can
Go
discharge.
approach that MP again to get a posting for you. He stays where he was.
Milords, try to that.
He stays where he was.
Ruling things at all levels
Yes,
of political to get a posting, all on record. What do we do about
Milords,
that?
try to that. In fact, try to please recommendations, Milords. I was already
So
proposed.
you took a step which you should not have been very
I
careful.
understand that should not have been done, Milords.
For the time.
Not have been, people suffer for the consequences.
Can't help.
See on the next day, that is why you should notice.
Sure, we are on the manner in which you entered that particular posting.
Milords, then Milords, like,
Absolutely shocking.
Yes, next.
then Milords, he has to, in any case, Milords, the government can transfer after 31st March.
Let us
Come and
see,
take
let us
this. We should
see,
also
deal with the government.
correspondence on the petition, on the petitioner taking necessary steps. Right? So let the others be served. Next.
So the government has one and two are the government.
Yes, we have told you to issue note, serve them. Next.
Item 98. Lordship, please. Milords, I'm making it returnable, Milords.
No.
Lordship, please.
19 will have to go to the High Court. This is an SLP, and this you're coming to the route of the CDRC. You'll have to go to the High Court in terms of the judgment of this court. We'll give you liberty to approach the State High Court. Dispose it off. Yes.
Again, they should.
You are aware of the judgment, aren't you? You're not aware of that. That one.
But please, Milords.
20.
My lord, the very same High Court, my lord, granted relief, my lord, the old pension scheme, in a case where the writ petitioner bearing, my lord, appointed in the year 2004. But the recruitment process started in 2021, my lord. I can produce the judgment, my lord. The High Court said, the recruitment process started 2021. In delay, the respondent government will delay the appointment order issue. So the benefit should go. My lord, I appointed in that particular period, my lord, but only I joined in 3-4 days late, my lord. That is the reason, my lord, that I could not grant
What was
release.
your joining?
My lord, my joining, my lord, my appointment, my lord,
Your appointment was 26th of
26-3, my lord. My joining 1-4, my lord, 2003, my lord. The date, my lord.
According to them, your appointment was 1/4/2023. Show us the.
No. I joined.
Show us, please, document. That's their version. Show us the stand of the respondent.
My lord.
1/4/2003.
1/4/2003, I joined, my lord.
No.
Then show us.
I'll counter up with a bit. Page.
Delayed 1893 days.
Could you explain that, by the way? You're coming straight on merits?
My lord.
1819 and refiling also 252.
Filing
plus
delay is there, my lord. The delay is there because.
Explain it. Delay is all very well.
Well,
It's not
delay is-
state. You are a private individual.
The delay is there, my lord, because I approached.
Explain it.
The reason is this, my lord. I approached a local lawyer. The lawyer took time.
That version doesn't engage us.
That is the real reason.
You're coming on merits, completely overlooking the fact that
Well, this I could
we are
ruling,
not
my lord.
going to go on the ruling because you have come with a delay of almost 1900 days. That's long enough.
I agree, my lord, because
That's not
nobody,
delay.
this delay, my lord, nobody prejudiced, my lord, only I,
It's not delay.
my rights only deprived, my lord.
Condone the refiling, but dismiss on main filing. Next.
My lord, then I may withdraw this, my lord, I can take my remedy somewhere else, my lord.
What remedy?
Like, because my right is because my similarly appointed person already getting benefits, my lord. I can approach the claimant.
Withdraw the present petition while reserving his right to approach the respondents for appropriate, seek relief against the respondents for the, by filing representation. It reports against the respondents as contempt, as may be available. Leave as great court is granted, petition is dismissed as withdrawn. Yes. टाइम दिया जाए टाइम के
Appointment letter.
Yes, Lord. By appearing as the petitioner,
Yes.
I am directed to place the judgment of the Patna High Court.
Let's see the last order just to give us a recall. Give us a recall.
Sorry, Your Lordship.
Let's give us a recall. Last order.
Yes, Your Lordship. I was asked, Your Lordship had recorded my age criteria, and I was asked to place on record the judgment of Patna High Court, by which the only category that was changed was the academic qualification. Rest all the other categories of appointment remained the same.
Let's see that.
Yes. Your Lordship has D1.
That amendment of clause 8. Right?
Yes, Your
The
Lordship.
revised guidelines. D1.
Which is page number?
It's the last document, additional affidavit. Yes?
Paragraph 3, Your Lordship, of the judgment.
Okay.
May I read it, Your Lordship? Taking into consideration the aforesaid fact, we are of the view, now the eligibility criteria laid down by the state government requires to be modified in a sense that persons with intermediate qualification and having a diploma in education or BEd from recognized institutions should be appointed first. And in case of there being non-availability persons having minimum qualifications of intermediate, bracket class 12, should be appointed as para teachers, and thereafter efforts should be made to train them as provided in the letter. Accordingly, letter corrigendum by the state government be published in terms of the order passed by this court.
Right. Then we turn to the next page.
No, Your Lordship. Now we come to the previous additional document that we had filed, Annexure D2.
Yes, the next, not previous, the next one. Translated copy of D2 and
Your Lordship, that is a different argument that I'll address at the end.
where D2? Earlier one.
Earlier one.
1245, but that's a Hindi one.
Sorry, Your Lordship.
Are you referring to the one at page 8 of your earlier additional
Yes, Your
affidavit?
Lordship. The translated
Counsel,
copy.
if you are referring to the annexure 6, it came 2 years after your selection process happened.
No, Your Lordship.
Yours is 2004 transaction?
Yes, Your Lordship.
This annexure 6 which you have filed with your initial document, it is dated 1/7/2006. And the High Court order is also sometime after your advertisement.
The appointment.
Then they told to do something prospectively. It cannot date back to a
The
transaction.
process was stayed. The appointment process was stayed in the year 2004, and post this judgment of the Patna High Court, the appointment process happened.
Where is it that,
Your Lordship, Annexure D.
Establish that.
Sorry, Your Lordship.
how do you show that?
Yes, Your Lordship. Annexure D2 of the previous edition
Yes,
document.
to the typed version at
Yes,
page
Your
6.
Page 9, Your Lordship.
Page 9. Okay, page 9.
I'm reading amendment in clause 8 of guidelines revised for employment of Panchayat Shiksha Mitra bracket on contract. A guideline for employment of Gram Panchayat Shiksha Mitra was issued by the state government through resolution 336 dated 21/6/2002, which was duly amended, issued as revised advisory by resolution.
No, where are we doing?
पहले वाला additional affidavit in 9. इससे पहले additional affidavit लास्ट
अच्छा,
उसमें Annexure D1 or D2, right? D2 per day, no, page number 9.
Yes.
Your Lordship has that.
No, sir.
In light of the final order by the High Court of Patna in writ petition 12248 of 2004 regarding the process of appointment of Shiksha Mitra, the state government issued further resolution 845 dated 7/4/2005 after amending clause 8 in resolution 145 dated 11/8/2004 in the below mentioned manner. So, Your Lordship, the only criteria that was
When did you apply?
I applied on 21/9/2004.
1/9/2004.
Yes, Your Lordship.
Yes.
Very good. So, my age eligibility criteria was to be followed that on 1/1/2004, I should be more than 18 years and less than 30 years. My age eligibility criteria was I was 29 years and 6 months old.
Cut-off date was 1/1.
1/1/2004.
So where is the hitch?
So
Where is the hitch now?
you have been non-suited, that private respondent was directed to be reinstated. You've been ousted?
Yes, Your Lordship. I've been ousted.
So you are as a consequence of this seat becoming vacant
On the
due to
previous
unsuitability
respondent.
or removal of the respondent.
Your Lordship, I was appointed in the year 2005.
On what basis? Because the other person was not appointed.
No. I was appointed. I was the first person who was appointed to this post.
Why have you been unsuited?
Because, Your Lordship, the Patna High Court in the LPA have considered that my year of appointment was 2005, whereas the resolution that has been passed by the Bihar government, the 1458 of 2004, only wanted that on 1/1/2004 I should be less than 30 years old.
Where is that? On 1/1/2004?
That's what we are asking. Where is that
Where is that?
2004, you should be less than 30 years. Can you show any?
In extra D1 of the previous additional document that you had filed, Your Lordship.
When you file annexures like this, you shouldn't number them in the same manner. Now you have two additional affidavits, both have D1, D2. That's the confusion for future reference. Okay. Yes, D1 of the earlier affidavit, right?
Earlier affidavit.
Show us that.
Yes, Your Lordship. The translated copy is at page 6.
Yes, please. Yes.
The note, Your Lordship, below, where it is highlighted,
Age of the candidate.
the age of the candidate.
So this is not in dispute that the appointments were made pursuant to this very advertisement.
Yes, Your Lordship. This is not in dispute.
Take down the counsel for the petitioner has complied with the order passed on 5/2/2024 by placing on record the relevant documents. We have produced the documents, issue notice to the respondents on the petitioner taking necessary steps.
19 years.
Let's see.
Let's see what happens.
Let's see. They're not too sure. It's a
Right.
23 order, so. Oh,
Obliged.
Continue. Yes, Mr. Lord.
desperation.
Lord. If your Lordship will see the last order of 23rd January, we have come out with a scheme, Lord, 23rd January.
So if we are correct, we had said that data entry who have worked without any glitch and all, make a category for giving them preference. Why just remove them?
What we have done, they will all be accommodated, is our feeling. Just consider what we have done.
Extra P36.
Yes. Lord, first, your Lordship's order was that at the request of Senior Counsel and Learned Advocate General for the state of Odisha and other petitioners whose state government proposes to prepare a comprehensive policy to deal with regularization and adoption of data entry operators who have been serving since the year 2008, list on 1st March. First, Lord, I am conveying a request. The Learned Advocate General wanted to be here. He's down with a little fever, cough, cold, and he's not attending court at all. So he's not here. Now, secondly, my Lord, now kindly see P36.
This is
what we have.
Additional affidavit.
Yes. Application for permission to file additional document.
Yes, we have it.
All right. Now, this scheme is made. I'll just take your Lordship through it, Lord. The first para is only formal that they were appointed, etc. Kindly have from serial number 1. Government, after careful consideration, has been pleased to formulate the following guidelines to consider regularization of data entry operator. The case of data entry operator for regularization shall be considered against 606 vacant posts of direct recruitment of junior revenue assistant, hereinafter referred to as JRA, under the R&DM department. This is revenue and department.
When the next advertisement is issued is what?
No, we'll do it. There's not.
One of them has been rejected by the High Court.
There's not a problem.
Paragraph-
There's not a problem on that, Lord. Recruitment shall be made in accordance with the recruitment rule. Requisition shall be filed. This will be done very quickly, my lord. We have all approvals. Only we have not made it formal, subject to your lordships having a look at it. Now, kindly see serial number 6 and 7. Rule 18 of 2019 rule gives power to the state government to relax any of the provisions of the rule if it is necessary. Exercising powers of relaxation under Rule 18, state government shall relax the following provisions of the rules. Upper age limit shall be relaxed is first. Second, requirement of registering name in an employment exchange shall be relaxed. Third, minimum educational qualifications that he must have passed +3, which is graduation, that shall also be relaxed. However, he must be a matriculate. Then, my lord, in the total test is of 400. In addition, marks secured by them in the written competitivity, which is total 400 as Appendix 1. Data entry operator will be given extra weightage of 1.5 marks for every completed year of service, subject to a maximum of 20% of the marks, that is 80. Upon conducting the open competitive examination, a select list which shall include the participating data entry operators shall be drawn up in accordance with the rules. Then next, Lord, those data entry operators who do not make it to the select list for the purpose of direct recruitment shall not be disengaged. They shall be allowed to continue as such on contractual basis till they attain the age of 60 years, subject to satisfactory performance. That is the age of superannuation. Their remuneration will be given with the periodic raise. Now, please see the rule. What is this test?
No, just stop here. It appears to be pretty reasonable.
Everybody will get it, Lord.
20%.
80 marks additional.
1 minute.
It's a 20% is big. And then, because your grievance arose because they wanted to fill up and remove you.
Yes.
You are satisfied. They say, okay, we continue, even if you don't make it. Chances are that you will make it. 20% enough.
Show the judgment and can
That is under challenge for us. So we cannot, what we find reasonable, that is a tentative view. We are not going to go into nitty-gritty and each and every aspect of the judgment. Why should we go into all that?
So,
Not the case why we should be so academic about everything.
So, there are quite a few relaxations that have been asked.
Yes.
Very liberal.
Considered by the High Court.
Oh, very liberal.
Which one?
And maybe with
My lord, the same thing was suggested before the High Court.
Say that the High Court went
Now, if I may
We'll have
only
to say
make
that.
points here, my lords, otherwise I'll put my response paragraph by paragraph to this. My lords, my submission is this, that I
You will
can,
only be satisfied when they, across the board, they give you an appointment letter. That we will know.
my lords, that's not the
That appears to be,
that's the point.
after this much of relaxation and still you are unsatisfied, that is the only thing you want, straight away a direct appointment letter.
My lords,
Period.
may I? My lords, there were 2013 rules under which I had to be, there were also 309 rules. Under that 2013 rules, that is what has been implemented, certain people were given suo motu. I have produced those orders. They actually acted on 2013. Others went to the court. I have in my counter affidavit at least 5 orders passed by this court in identical fact, this court having dismissed the SLPs against the orders of the High Court, and more than, I think, 400 or 500 people have been given the benefit of 2013 rules and have been appointed. So we are the small
Rule stated, no, what did the rule state, 13?
My lords, they were rules of 2013 because we were earlier, government had actually financially sanctioned these posts originally for a period of 6 months to take us on contract basis. We continued for a period of 6 years on contract basis. So in 2013, the government came out with a guideline saying, people who have continued for 6 years, these people are found very valuable in the tehsils. They have been functioning for over 6 years. They will be deemed to be regularized. Because we had come through proper routes, we had been given regularization or the financial allocations were made for us. We were appointed for the purpose of carrying out the works at the tehsils, which we had carried out. We were originally 6 months. We had been continued by which time for 6 years.
This is all not
But
correct.
my lord,
Just
I
give
can
us
show
the-
from the orders. My learned friend may not interrupt now because I can show this from the judgment.
Miss Arora, thereafter came another GA.
So therefore, that what came to be challenged before the court was that under 2013, these people have to be regularized. Now, over a period of time, orders were passed in a batch of matters for different persons, identically situated. My lords may take my counter for a moment now, Please, my lord, filed in the case of Gopal Krishna Bhagati. Yes, my lord, it's SLP number 168.
If they are not accepting it is to be argued, then I have to open the case, Lord, because what she's saying is all correct.
If I don't accept,
If you are not accepting, then we.
so my lord, right, then we will keep this aside and hear first him on merits and then proceed. Then you can't be put.
Yes.
Then we'll go to review and withdraw this.
No, we haven't made it final. We haven't made it final. It is still subject to your lordship and their state.
This is covered.
No, then we'll make a
Argued each one of this before the.
make a categorical observation that now this concession shall not be available. Ultimately, what we decide on merit.
Yes. Now say they have given an option, it's not acceptable to you, and we will have to hear the matter on merits. Is that okay?
If it is okay, we'll do that. But now, no going back on this.
So, my lords, I can also say that if my lords may look at annexure P6 in the SLP.
No, we don't want to see.
No, we are just wanting a initial.
Mr. Arora, we had directed them, whatever you want to show will be after we put it on.
Yes, my lord.
So we will record, are you okay with it? We are recording your statement that you are not accepting, my lord.
I have my instruction.
Very good.
Very good.
My colleague now says that my lords may hear this on merit.
Yes, the petitioner has placed a draft resolution on, has enclosed a draft resolution with IA 53505 of 2024. Stating inter alia that the said resolution that the state is willing to pass the said resolution, which is a comprehensive policy to deal with regularization / absorption of data entry operators who have been serving in the state government since the year 2008. Stop. Mr. Arora, senior advocate appearing for the respondent, states on instructions the respondent is not willing to accept the terms and conditions set down in the resolution, the terms and conditions, the concessions given in the resolution.
The resolution is proposed. No, Mr. Patwari, it is proposed or
It is proposed. It is proposed.
We have said may record resolution.
May record why I am not accepting that.
No. Set away.
I want to say each one of them is rejected by the High Court. What is proposed?
That order is under challenge.
Number two, my lord,
We don't want to.
all the others have
Mr. Arora, rights on
That is on merit.
That
is on merit.
This is
that the draft resolution, the contents of the resolution are not acceptable to the petitioner, to the respondents, and the matter would, and the matter ought to be taken up on merits. Say that issue notice, counter affidavit will be filed within 4 weeks, rejoinder 4 weeks thereafter.
So in a large number of matters, notice is not issued. Notice has to go in there.
Wherever notice has not been issued, say notice be issued. Wherever counters are not filed, counters will file. Tell us which matter shall we treat as a lead matter, we will treat it as a lead.
16949 of 2023. Is that okay?
17482 of 23 Why not 1748?
All right, Bishop.
yes.
With the consolidated.
1782.
With the consent of the parties, SLP civil number 174.
All right, 17482 is also. There is no problem.
Lead matter for purposes of argument. Say that list on, was it a stay granted to you?
Yes, Lord. For contempt proceedings have been stayed.
Next.
We have not filed any contempt.
Some parties may have. Some
All right.
parties may have.
Whatever in that was.
First order is indicated already.
Yes.
Next.
Same order.
List after services.
Great.
Lords may just give a return.
No returnable date. After services complete, there are notices yet to be issued in many matters. Next, please.
My lords, you can accept.
Yes, 20.
My lords, we have filed vakalas, we will accept notice in the other matters also.
All the other
We'll file them.
Another matter. Very-
There are two
Very
which are left, we will file our vakalas and we'll take.
Not, how many matters are this? There are 32 matters.
32 matters.
There are 32 matters.
My lords, in 30 matters, wakalats have been filed. There are 2 matters. My learned friend will file the
All
wakalat.
right, very good, very good, very good.
Issue notice to the respondent
Yes.
in the matter.
28 also is.
1 minute in the matters in which notice is yet issued. Learned counsel for the respondents accept notice and state that they will file their power of attorney. Within 1 week, the counter affidavit be filed. Then say, in an order, readings be completed. List after thereafter complete. 4 weeks, 4 weeks.
All right, 28 also.
28 along with 22. Anybody in 28 on the other side accepting notice? That notice was.
Shripanta Biswal and
No, all right, wait, it's the same.
Same then tag with the lead matter 23.
Great.
Next.
Here, my lords, the same issue. Lordships have issued notices in 2 of the matters that I pass on those orders. On the same issue as to whether the live registration should be there, and if the live registration is not there, what would be the consequence?
what registration?
Because under the employment exchange, live registration, the employees have to register themselves.
Yes. Which is the first matter, 28/11/23. Is that? And
Monica is the lead.
Name or order is different.
Different orders. Monica is the lead matter.
Issue notice. Tag with SLP diary, civil diary number 38819 of 2023. I put Setu Madhya Pradesh and other versus Monica, Shakya and another.
There's
They are the orders.
some delay in those and some delay in filing the SLP. 55,
10 is
yes,
closed.
the filing. Great, obliged. 24.
24 and.
The matter. This is enough.
Also,
Is leading us, he's on his legs.
you're on KVA.
We have filed Bakar. We have put the response.
Notice has been,
State, you are for the state of West Bengal.
We are for the board primarily.
yes, what development, Miss, what development?
We should come in appeal against the interim order. Yesterday, the case status is showing in Calcutta High Court.
Yes.
That the matter seems to be disposed of. We don't have the order with us.
Find out. Both of you find out.
I'll take instruction.
Because that is an interim order here.
Yes. So
Now
now
this will become infructuous. as it-
we are instructed that final orders have also been passed.
No, but if
If you
you,
are instructed, you withdraw it.
no, and if you got it from the net, then why not?
We just found out from the net.
So that is authentic. If it is from the official website of the High Court,
I'll have to confirm it. My
It is official website printout.
it
status.
is on the official website,
It's official website printout.
then why could you not
I'll have to.
rely on that?
The anxiety is this, because the order has not been uploaded and we don't know when it will be uploaded.
Let's take a few days. It's official website printout.
Give a copy to your colleague. There was case
Closed
closed
out.
off on 29th of February 24.
Yes, Your Lord.
Take down.
Leadership may keep this pending, I'll file a fresh SLP against that.
Why would we keep this pending? We'll
Because-
discuss it talk.
because
Take-
if the-
give you liberty to take your remedies in accordance.
Just put something, Your Ladyship, that the
Why
order
does
is
it
not
say, why
uploaded.
does it say appellate site, Calcutta High Court? This
Because there are original site and appellate sites. This is appellate site, but because of the latest patent there.
Take down.
Your Ladyship, may I just say something, because we don't have the order and we don't know when the
Doesn't
order
matter,
will be
whatever
uploaded.
it is.
It's a fresh cause, counsel, it is a fresh cause of action, so.
Because I.
No, not in this. This has to go.
Your briefing counsel very viciously thinks we permit you to.
Not this. It has to be a separate
Take
transaction.
down, senior advocate, Mr. Vivadandavaki, senior advocate, appearing for the petitioner, state, hands over a copy of the, what is this document?
His status from the official website.
Just from the official website of the
High Court.
High Court of Calcutta, to state that case number, what is this number? Number?
WPA 16.
That WPA number 16118 of 2023 was disposed of 9 February 2020. The order passed has yet to be uploaded. Mr. Be that as with.
Lordship, I think the order is
No,
also.
no, the party name here is Kaushik Das.
No. That matter, he challenged it here, we shall possibly fight.
Interim order.
There are multiple parties.
Lordship, I have the order.
Well, we got it.
I've got the order.
That in view of the aforesaid development, the present petition is disposed of with instructions with liberty granted to the petitioner to seek appropriate legal recourse again if aggrieved by the order dated 29th of February 2024.
Yes, I have the order.
Record time statement.
Should I bring that order on record?
We will not say SLP.
Ladies, may say
Appropriate legal recourse.
Should I be permitted to file this copy of the order? It is available.
It's a fresh cause, everything is open.
It's open.
Lordship, the order is available, if I may be permitted to file, it is available.
Oh, it's available.
I have checked it.
Download it and give a copy to your.
I'll email to Lordship's court master.
To the court master.
Yes.
Next.
Just keep.
give it to us so that we can expeditiously.
Everything is open because I just disposed of with an interim order.
We are not.
Finally, it has been disposed of. Final disposal has a fresh cause against it.
Entirely now for you.
Maybe to some technical glitches that we are not.
No, because we are using it from day one, we know.
Next.
Great.
Was in terms of the order and find the relevant deals and amendments thereon.
Yes, let us see that. This is that each unit vacancy is put on a unit-wide basis. Where do we look?
Was the GO dated 31st of December 2015 is with respect to training only.
Which page?
Milos, I will just find. Milos, page 85, Milos.
Yeah.
Because this is in continuation of the rules of 1999, which are also training rules. This whole GO and the rules itself does not provide the recruitment or the allotment process.
What are you saying?
Please, Milos.
No, we've not understood. What
Milos, these rules that were mentioned in the notification